Judge, I know that when you work with Tom, you talked about how Tom kind of takes care of a lot of the federal rules, and I was wondering if you'd be kind enough, can you give us an example or maybe two of the type of federal rules that the new Illinois code did not adopt?
Okay, that's probably a very good idea to do, because we're concerned that lawyers will simply say, oh, it's just the federal rules.
Right.
But it's not. The numbering is the same, but the rules aren't the same. We did not, for example, adopt the residual or catch-all exception to the hearsay rule that's contained in Federal Rule 807. We had debate about it and decided not to do it, that it was too much of a snare for the unwary. We didn't adopt the hearsay exception of present sense impression, 8031. We expressly discussed it and said it's not good Illinois law, and so we didn't adopt it.
So we talked a little bit about a federal rule that we didn't adopt. Let's talk a little bit about a rule that is not part of Illinois law that you did adopt from the federal statutes.
Yeah, there are several. For example, we have adopted the federal procedure for establishing the foundation for business records. It's a certificate, sworn certificate procedure, which when used saves a lot of time, because you don't have to bring in people to say, yes, that record was made and kept in the ordinary course of business. And that's in the rule that was never in Illinois law before. Something else we did was to adopt Federal Rule 806, which has to do with habit and routine. It used to be the Illinois common law. It was very unclear, but it was the common law that you couldn't put in habit testimony unless you had corroborating circumstances, and it wouldn't be admissible if there was an eyewitness. And that was old common law. It made no sense. And so we abolished the old requirement and adopted the federal rule, which says if it's relevant and you have a proper foundation, it's admissible. So that's a big change.